So you want to pass that real estate exam? Well, this is how you do it. Reviewing national and state questions, understanding what they're saying in the question, reading it carefully, and knowing the key words to help you make it the correct answer. So that's what we're doing today, national and Texas state questions. And of course, vocabulary, always vocabulary. You're learning a new language and it's a must. Anybody watching the replay, these classes are designed to help students participate during the session. So fast forward if you don't want to wait until the answers are being put up, because I do give them a chance to answer. So let's get with it. All right, number 346. And if you're on your computer or your phone and it's blurry, so that's the resolution on your computer. Okay, and so what you need to do is on your screen for YouTube is go to the bottom of the video and click the screen and you'll see a gear and you'll be able to set the resolution to 720. All right, number 346. A construction contractor executes a contract with a buyer. In the agreement, the contractor promises to complete construction by November 20th. This promise can be construed as A, an option, B, mutual consent, C, a meeting of the minds, or D, valuable consideration. Type your answer in the chat. All right, so the answer here is, anybody? It is valuable consideration, D. So it says contractor executes a contract with a buyer, right? So you've got a contract, an agreement between the two, just like a buy and sell contract. In the agreement, contractor promises to complete construction by November 20th. So the promise is a promise for a promise, right? Good morning, Cindy. So it is valuable consideration just on a real estate resale contract or any type of real estate contract. We have a consideration and it's a valuable consideration. Does not have to be cash. All right, so that was 3.6D. Good morning, Melanie's. Thank you for joining us today. All right, number 47. Okay, all right, yes, morning. 47, a seller contracts to sell a property that she does not own. The sale contract for this transaction is A, is executable, B, must be in writing, C, is void, D, is illegal yet potentially enforceable. So seller contracts to sell a property that she does not own. Good morning, Kamanani from Westside, Houston. Check that out. So Melanie's Harris. So where's everybody watching from? So we've got Kamanani from Westside, Houston. So type your answer in the chat. Can you sell somebody else's property? Well, you could try to, right? Yes, the answer is C. So the content promise of intent of a contract must be lawful, and this is not lawful, right? A contract that proposes an illegal act is void. They don't own the property. Right, number 48. Okay, they didn't quite fit. Got to maneuver my things around here. All right, 48. Good morning, Kathleen. So the statute of limitations requires that parties to a contract who have been damaged or who question the contract's provision can do what? Okay, they all start with must. And sometimes I say when an answer starts with must, is that you really have to do it, and some things you don't. But in this case, they all start with must, so that's not a key. So statute of limitation, what does it require? That the parties to a contract do: A, must act within a statutory period; B, must select a specific limited course of action for recouping their losses; C, must arbitrate prior to taking court actions; or D, must wait a statutory period before they may take legal action. So there's always steps, right? Because everybody has to do their specific performance, right? Buyer, seller. Must act within a statutory period. No, the answer is not A. The answer is B. Must select a specific limited course of action for recouping their losses. B, yes. So your first one said A, must act within a statutory period. So the the statute of frauds requires that certain contracts must be in writing, right? Anything over a year, like a lease over a year, has to be in writing, and all other contracts to be enforceable, right? So real estate contracts that convey an interest in real property fall in this category, with the exception that a lease of 1 year's duration or less may be oral, right? So there is a limited course of action for recouping. So the statute of limitation does require that parties to a contract who have been damaged or who question the contract's provision must select a specific limited course of action. So the contracts will have, specific damages that are taken care of. And if that doesn't work, then they can go to mediation, then arbitration, and of course, eventually litigation in court in order to recoup their losses. There are specific steps to take. And several of you answered A, right? So no, it's not a statutory period of time at this point. The contract specifies what they can do. So process of elimination. All right, number 59. Oh, sorry, 49. Jumping ahead here. So the purpose of the statute of fraud is, the statute of fraud. So there are laws, right? A, invalidate certain oral contracts. B, require certain conveyance-related contracts to be in writing. C, nullify oral leases and listing agreements. D, eliminate fraud in real estate contracts. All right, come on, type your answer in the chat. This is the time to do it. So if you happen to get it incorrect, because remember, we're not failures. We just realized that we have to study more and study in the correct ways, okay? So the answer here is B. So require certain conveyance related contracts to be in writing. So anything over a year, at least that is less than a year, of course, can be oral. But all other contracts must be in writing. So one of the things, so the purpose of statute of frauds is it to invalidate, require, nullify, or eliminate? So it's to require. That's one of the key words. It doesn't eliminate fraud, right? People are always some people will be fraudulent no matter what. And it doesn't invalidate. So the key word in the answers is require certain conveyance related. Good morning, Carol. Thanks for joining us. Ooh, I haven't been showing the answers. Pardon me. Okay. 347. Oh, Cindy. Yeah, you're from Corpus. 46D. Yeah. So there we go. So who answered? Pearland, Texas. Okay. So we've got Kamanani from West Houston, Melanie from Pearland, Texas. We've got Cindy from Corpus Christi. Let's see. I missed it. Corpus Christi. So all Texans here today. 3.49. Yes, okay, I already answered that. All right, number 50. A seller immediately accepts a buyer offer, but waits 10 days before returning the accepted document to the buyer. Meanwhile, the offer has expired. Which of the following is true? A, the buyer is bound to the contract since it was accepted immediately. B, the buyer has no obligation to the seller whatsoever. C, the buyer may not rescind the expired offer. Or D, the seller may sue for specific performance. Okay, so remember what happens in contracts, right? We always have to notify, right? When is the action complete? Good morning, Ruth, coming from Houston, and I'm in San Antonio, Texas. So seller immediately accepts offer, buyer's offer, but, okay, there's a but, waits 10 days before returning the document. So how is the buyer going to know that the seller accepted? So in the meantime, buyer has options. Okay, so what is it? Buyer is bound to the contract, buyer has no obligation, the buyer may not rescind, or the seller may sue. That's right. The answer is B. The buyer has no obligations to the seller whatsoever because it expired. The offer has expired, right? When a seller doesn't respond in a contract, that can automatically be considered, that's a rejection, okay? They didn't respond in a timely manner. The contract doesn't specify whether to respond in 24, 48, 72 hours or immediately. It's just when the seller accepts, the buyer has to be notified. If buyer doesn't receive notification, they're not aware of it, and it expires, there's no obligation. Remember, there has to be notification. What was it here? Okay, so now we're going into agency listing agreements. So that section. Okay. Okay, test number 3, okay, had to do with land use, legal descriptions, and contract law. Okay, so those last few questions were on contract law. So now we're going into agency and listing agreements. So keep your mind aware about agency and listing agreements. So the agency relationship is defined by what? A, the Realtor Code of Ethics. B, the laws of agency, or in some states by statute. C, the law of real estate contracts. Or D, the agreement between principal and agent. Type your answer in the chat. Let's see. Melanice, are you replying to 4.1? If so, type your question number, please, so that we know which question you are responding to. All right, so agency relationship is defined by the laws of agency, or in some states by statute. Okay, it's not just the agreement between principal and agent. Okay, that is an agency relationship. However, how is it defined? By the laws of agency. Okay, so you're taking principles of agency, right? Principles 1 and principles 2, principles of real estate. So know that it's the laws of agency. That's how the agency relationship is defined. So in every state, okay, you have the agency, the body of laws, right? The legislature, generally called the law of agency, defines and regulates the legal role of their relationship. While the relationship is subject to contract law, agency law dictates how the relationship will achieve its purpose, regardless of what the listing contract states. All right. Y'all get that? So a lot of you answered D, the agreement between, that's an agency relationship. However, it says that the agreement between principal and agent. However, it's asking for the agency relationship. How is it defined? It's not defined by the agreement between a principal and an agent. That's when we have an agency relationship. However, it's defined by the laws of agency. You know, there's a difference. Okay. All right. Number 2. Makes sense. Good, Carol. All right, number 2. Okay, so which of the following is true of the connection between compensation and the agency relationship? Okay, what is true of the connection between compensation and the agency relationship? A, an agreement to give and receive compensation creates an agency relationship. B, if an agency relationship exists, the principal must provide valuable consideration to the agent. C, the relationship is independent of any compensation agreement. D, if an agency relationship exists, the agent is entitled to compensation. So it depends, right? How we get paid and when. So type your answer in the chat. Remember, this is dealing with agency and listing agreements. All right, so here the answer is actually C. The relationship is independent of any compensation arrangement. Okay, when we have a buyer, okay, yes, there's a buyer representation agreement, but the relationship is independent of that. Okay, we're going to represent our client. Let's see what the book says. So it is important to understand that the agency relationship does not require compensation. Okay, because you might be having a repeat client that you want to do a pro bono. Okay, you don't want to charge them. They've provided lots and lots of business, made a lot of money. So it does not require compensation or any form of consideration. Nor does compensation define an agency relationship. A party other than the principal may compensate the agent. All right, defined, got it. All right. What did I say? 4.2 was C. Excuse my sniffles. Man, as soon as September hit, it's like, whew, allergy time. Okay, number 3. So any questions? No. All right. One of the parties to an agency relationship defaults and the agreement terminates. So we have a two-sided, right? Bilateral contract. So one of the parties defaults and the agreement terminates. Which of the following is true? A, all obligations are extinguished. B, both parties must continue to perform all other obligations of the agreement. C, the defaulting party may have a financial consequence. Or D, the damaged party has no claim against the defaulting party. Always remember to read the questions carefully and the answers. We sometimes make the mistake of reading them really fast, right? Because we believe we're running out of time, and we could be. Yes, the answer here is C, Melanie's. So the defaulting party may have a financial consequence, right? So it says the one of the parties defaults and the agreement terminates. So are all obligations extinguished? No. Both parties might continue to perform? No. So what happens? The contract specifies what happens when there's a party that doesn't follow through with their specific performance, and that the defaulting party may have a financial consequence. D, it's not an option, right? That they don't have any claims. Number 4. Among the fiduciary duties imposed on a real estate agent, it is the requirement to do what? Okay, among the fiduciary duties, what is it, old car? Imposed on a real estate agent is the requirement to, so one of the followings is a requirement. A, refuse offers the agent knows will be unacceptable to the principal. B, present all offers to the principal regardless of their amount. C, advise the principal against accepting an offer that is below full price. Or D, advise a prospect that the principal will not accept the prospect's offer in order to elicit better offers. All right, so far we have B. And yes, that is correct. Good morning, Dan. Thank you for joining us. So the answer is B, present all offers to the principal regardless of their amount. Okay, so if the principal tell us, good morning, Taylor. Well, good. I'm glad you're listening. Yeah, don't do any typing because you're driving. You're very welcome. So 4.4B. Okay. So let's see here. Did I type the answer? Good morning, Uma. Okay, so let's see. Facebook user. Go to facebook.com. Hold on. Let me, I'm sorry. Go to I'm going to type on here before leaving a comment. Let's give StreamYard permission to post your name. Okay, so Facebook user, do this for me. It takes maybe 15 seconds or less. So go to that website on that I just posted on Facebook and on here, StreamYard.com/Facebook, and give StreamYard permission to post your name from Facebook, just like we have Uma here, okay, or Kamanani, instead of, let's see, this. Okay, that way we all know who it is that's here present. Okay, so we always present all offers, whether the seller doesn't want to be presented lowball offers or offers by certain, individuals. If that's the case, it's best to terminate any relationship with a client. However, we present all offers unless they desperately put it down in writing, because that is our legal obligation. Oh, thank you, Kamanani. Oh, I love comments like this. You rock. Yeah. And with helping us to learn real estate. Okay, well, pretty soon I'll be doing shorts and, 1 minute shorts, giving you different topics or vocabulary. Number 5, one of the agent's fiduciary duties that continues even after a listing agreement expires is what? Yes, this is easy. Old car, right? Yes, Cindy. Come on, y'all. Type your answer in the chatty chat before I move. Awesome. Yes, the answer is 5C, confidentiality. That remains, just like with an attorney, a doctor, an accountant, that remains. Our agency relationship ends, once we close a sale or a purchase. However, the confidentiality remains. Because, right, that's when the agency relationship ends, when it closes, and we get paid. All right, so Kamanani says, I failed 3 times now. I have 3 more tries. Now that I retaken my additional hours needed, I will schedule my first try round 2. Awesome. So what, Kamanani, why don't you share with us what were the classes or the courses that you had to repeat? So that others know, because a lot of times individuals that don't pass for 3 times, not sure what they have to retake. Hey, Melanie, you just added another letter to the answers, an E. So Kamanani, what courses did you repeat, or what courses did you take? Was it one of the 6, 2 of the 6 courses? Type your answer in the chat, please, while I read the next question. Number 6, the standard of care and competence that a principal can expect from an agent is generally that which is the standard of care and competence that a principal, right, seller or buyer, can expect from an agent is generally that which is A, specified in the agency agreement, B, necessary to earn the promised compensation, C, necessary to procure a customer, or D, comparable to that of other practitioners in the area. Oh, I got different kinds of answers here. I've got A and we've got D. Okay, and the answer here is D. So the standard of care and competence. So what standard in the industry of professionals that a principal can expect from an agent is generally, generally kind of broad, that which is D, comparable to that of other practitioners in the area. So the answer here is D. And I'll review. And I'll go back to Kamanani's answer in a moment. Okay. So the agent is hired to do a job, right? We're hired to do a job and do our performance, and therefore expected to do it with diligence and reasonable competence. Competence is generally defined as a standard of practice. So standard of care, standard of competence is a standard of practice. Okay, equal to the level of real estate marketing skills and knowledge of others practitioners in the area. So the answer with D. Let's see, we had A. Good morning, Michael. Thanks for joining us. A, specified in the agency agreement. No. So it's a standard of care. It doesn't have to be specified in the agency agreement. Okay, which it is, but it's the comparable to other practitioners in the area. So we have to have competence and care, right? In order to take care of our clients, and diligence. Okay. All right. So darn, says Cindy. All right. So Kamanani said, okay, didn't pass the first 3 times. So took 2 more courses. And what do you repeat? You repeat one of each of the 6 courses, one for the state, one for the national. So she did Principles 1 and Principles 2, right? Because that is the broad topic that we're dealing with in real estate. Principles of Real Estate 1, Principles of Real Estate 2. So whenever you don't make it for the 3 times, okay, you're not a failure. Yes, it says you failed the exam. However, we are not a failure. We just realized and we learned that we were not totally prepared for those exams, and we have to do more studying, be more diligent, have a schedule, be focused, and understand the material. So thank you for that, Kamanani. So number 7. Okay, Agent Michael is showing his new listing. Hey, Michael, you're an agent already. Almost, huh? So Agent Michael is showing his new listing to a buyer who informs him that he has just inherited $5 million. Michael is now bound by fiduciary duty to do what? A, keep the information in confidence. B, disclose the information to the buyer's agent. C, disclose the information to the seller. Or D, verify the buyer's statements before disclosing them to the client. So Agent Michael is showing his listing to a buyer who lets him know, okay, that they just inherited $5 million. Okay, so look, Agent Michael represents is showing his listing, represents a seller, okay, to a buyer. Doesn't say the buyer is their client. So they're a customer, right? And what can we do when we get information from a customer? We have our fiduciary duty to our client, right? The seller. And that buyer informs them, hey man, I just inherited $5 million. What is Michael bound to do by the fiduciary duties? C, yes, disclose the information to the seller. Okay, because he represents a seller. Anything that we learn and we find out and we are aware of, we inform the seller because that's who we represent. That's our fiduciary duty. So Kamanani and Melanie's and Cindy, awesome. Okay, those of you that answered A, hi Yesenia. Keep the information in confidence? No. They don't represent the buyer, okay? Michael represents a seller, and that's who Michael has to keep the seller's information. So if the seller said, hey, man, I got millions and millions of bucks, I'll accept any offer. Is he supposed to go tell that buyer that? No, that is confidence, because we have a confidential relationship with our client and the seller is his client. Okay. So what other answers did we have? Okay. So let's see what Carol says. In the exam, that hard, nervous. Yes, it is hard, but it becomes harder when we don't study on a regular schedule, like every day. Okay, it is a must. In order for you to pass these exams, okay, it's important to study a little bit every day. If you can't study a lot, and to schedule a time on your calendar, let everybody know that's around you, focus, get a private area, okay, for you to concentrate, use music you like, a scent that you like, a diffuser, put your cologne, how you feel the best, okay? Then you focus on studying. And if what you've done in the past has not worked, you've got to retrain yourself. Go listen and watch some videos on how to study. I did put one on here. And there's different authors like Jim Quick, okay, that explains that topic on how to go about studying in 20-minute sessions, and organize your study. Figure out what your weakness is on, what you've got to focus on. Learn that vocabulary. Don't just memorize. Enjoy learning. Okay. So Facebook user Dan says, these are trick questions if you don't pay attention to detail. That is correct. Pay attention to detail and the little keywords. Okay. Those little keywords. Okay. That I am getting better at pointing out to you. What are we on? 4.8. Gosh, it's going to be small. All right, 4.8. Agent Jerry has executed an exclusive buyer-broker agreement with the Andersons. Okay, Agent Jerry executed an exclusive buyer-broker agreement with the Andersons. The agent subsequently places an offer with Melinda, the exclusive selling agent for the Lincolns. So Melinda represents the Lincolns. Jerry, a broker agreement with Anderson, exclusive buyer-broker agreement to buy their lakefront property. So the Lincolns own the lakefront property. The offer contains provisions for the Lincolns to pay the brokerage commission, which the Lincolns agreed to. Given this set of circumstances, Jerry owes the full set of fiduciary duties to whom? A, the Andersons, B, the Lincolns, C, Jerry's broker, or D, Melinda's broker. Who does Jerry represent? Okay, Jerry represents exclusive buyer, Andersons. Okay, Melinda represents exclusive client, Lincolns. Yes, very good. So the Andersons, right? So Jerry represents the buyer, and the buyer is the Lincolns. I'm sorry, the buyer are the Andersons. Excuse me. So yes, the buyer are the Andersons. So the answer is A. Very good. Okay, what does Kamanani say on here? Says, yes, we have to study every day. If we are not in real estate, new to it, if we're new to real estate, all real points needed are valuable. Thanks, Ms. Lillie. Yes, you're very welcome, Kamanani. Yes, and I stress over and over the vocabulary. And you will hear that from other online tutors on YouTube and Prep Agent Joe Juder. Okay. He stresses that a lot and has lots of videos on vocabulary. And so do I. Okay. However, they are the least watched videos. So I repeat myself: vocabulary, vocabulary, vocabulary. Okay. So that you understand the material. and be able to pick things out quicker on the answer. All right. 48A, yes, very good. All right, number 49. Let me see if I can get that a little bigger. No. A sub-agent is the agent of whom? A, the seller. B, the buyer. C, a broker who has an agency relationship with a client. Or D, the client's and the customer's agent. Ooh. So a sub-agent, a substitute agent, right? So when they're a sub-agent, they do not have what? An agency relationship with a buyer, right? So they are what? Yes, very good. The broker, C, the broker has an agency relationship with a client. So the sub-agent is an agent of the listing broker, okay, who has an agency relationship with their client. And that's who the fiduciary duty is given to. We actually, in some companies, do not practice sub-agency. We make sure we have a buyer representation agreement. I'm with eXp Realty, and therefore they do not allow us to be sub-agent or pay a fee, a commission, share our commission, let's see, as a listing broker with a buyer agent that doesn't have a buyer's representation agreement. So whenever I represent a seller, and on the listing agreement, I type on the commission that was agreed upon between the seller and the buyer. I'm sorry, between the seller and the broker, the seller and me as the associate of the broker. Then I can only put for MLS users, okay, and realtors, not sub-agents, 0 to sub-agents. Some brokers may allow it. My brokerage does not. And it's best to have a client be represented, a buyer to be represented. They think they're saving money by not being represented, and they don't realize that they could do much better. They will do much better with a very competent and experienced realtor. And when you start, you're not going to be experienced. You're going to be learning. So what you lean on other realtors and brokers and mentoring and classes in order to get good at knowing how to represent your clients. All right, number 10. Which of the following is a dual agency situation? Remember, these are national questions. A, 2 agents share the exclusive right to represent the same client on all transactions. B, 1 agent represents both sides in a transaction. C, a selling agent from one brokerage works with a listing agent from another brokerage to complete a transaction. D, 1 agent represents 2 sellers at the same time. So dual agency. Not intermediary, okay? Not to be confused with intermediary in the state of Texas. These are national questions. So far, no, it is not A, Kamanani. So there are many of you on here today. So come on, please participate. Let us know who you are and type your answer in the chat. Let us help get you to answer the correct, select the correct answer. So the answer is when you have a dual agency, 1 agent represents both sides in a transaction. So when I was in Oregon, I was a broker in Oregon. Over there, we were called the principal broker, which is the same as broker in other states. And so I could and even as a realtor, I could represent both sides. So I'd have my listing hat on, take it off, and put a buyer hat on, okay? Or not put a hat on. And I really got good at helping and representing both sides, because we have to. It's very tricky for a lot of realtors that don't have experience, okay? to try to represent two sides in some of those states. So 410 is B. One agent represents both sides. Yes. Number 11. Darn, can't seem to get the right size here. All right, number 11. 4Q, Kamanani? I think you meant 4B. All right, number 11. The duties of a transaction broker or facilitator include, okay, the duties of a transaction broker or facilitator, okay, include A, preserving the confidentiality information received from either party. B, helping the two parties achieve their respective objectives. C, disclosing material facts that affect the value of the property to both parties. Or D, choosing to obey the instructions of one party and informing the other party of the decision. So the duties of a transaction broker. So you have a deal going, okay, a transaction, or facilitator. Yes, very good. The answer here is C. Disclosing material facts that affect the value of the properties to both parties. God, I keep saying properties, to both parties. So disclosing material facts, okay, anything that has to do with the property that affects the decision of the buyer or the seller. So disclosing material facts that have the value of the property to both parties. Okay, anything that affects the value, okay, affects the decision making of either party. Very good. Number 12. Which of the following contact situations would a seller's agent be expected to disclose his agency relationship? Okay, so in which of the following contact situations, we're in contact with a buyer or with a seller. And this is would a seller's agent be expected to disclose his agency relationships? In which of the following contact situations? Okay. A, the agent is showing the client's property to a prospective buyer. B, the agent tells an acquaintance at a party about the client's property. C, the agent answers questions about the client's property for a telephone caller responding to a newspaper ad. Or D, the agent is showing a potential buyer houses in a certain price range in the multiple listing book. Wow. We no longer have, in my age of in real estate, we no longer use multiple listing books, but I was involved in the time where there were multiple listing books instead of getting online and getting into the MLS. So the answer here is A, the agent is showing the client's property to a prospective buyer. So in which of the following situations contact? So we're in contact with people, right? Buyers or sellers. And would a seller's agent be expected to disclose the agency relationship, right? That seller's agent has a relationship with the seller. So whenever they're showing their property, the client's property, their seller's property, they must disclose, hey, I represent my seller. So with this particular property, I can only offer you any information that is public to everyone. You know, the listing information from the MLS, any other documents, property details. I cannot negotiate or advise you on this property. Other properties, yes. So the agent is showing the client's property to a prospective buyer. Very good. Number 13. The essential foundation of the agency relationship consists of Okay, the essential foundation of agency relationships. A, must mutual respect, compensation, and confidentiality. D, diligence, results, and compensation. C, service, marketing, and respect. D, good faith, trust, and confidence. The essential foundation of the agency relationship. No, it is not A. Sorry. Well, I'm not sorry, right? But it is not A. Hi, Ruth. Nice to have you here. The answer is D. Okay. So the essence of the agency relationship is trust, confidence, and mutual good faith. The principal trusts the agent to exercise the utmost skill of care, fulfilling the authorized activity, and to promote the principal's best interests, right? The agent undertakes to strive in good faith to achieve the desired objective and to fulfill the fiduciary duties, right? So the real estate commissions want to know that we're honest and trusting, right? So A doesn't have that, doesn't have honest or trust. So the diligence, results, compensation, well, that's not the essential foundation. Essential foundation is good faith, trust, and confidence. Because we even get questioned about that when we fill out the application, you know, honesty and trust. Those are the main essential foundations. Okay. I mean, yes, the others are important where, you know, there's going to be compensation, hopefully confidentiality with our particular client. And we provide a service, we do marketing, we respect them, we're diligent, we get results sometimes, okay, and we hopefully get compensation, right? But the essential foundations, good faith, trust, and confidence. So most everybody got that right. Oh, I thought somebody answered A. Yes, and B. All right. So the answer, which one again? D. Number 14. Audrey wants to take a vacation. Yeah, me too. Vacation, right? To do so, she authorizes an agent to conduct the operations of one of her business enterprises. The kind of agency she has established is, okay, so Audrey wants to take a vacation. So she authorizes another agent to conduct the operations of one of her business enterprises. The kind of agency she has established is A, limited, B, general, C, universal, or D, special. So she's conducting all the operations of one of her business enterprises. Type your answer in the chatty chat. The answer is D. Okay. 414, not D, I'm sorry. B as in boy. B as in boy. A general relationship. Okay, a special relationship, okay, is when you're dealing with one specific property. One realtor, one specific property. When it becomes a business enterprise, then you must have multiple properties, okay? Multiple relationships, multiple agreements, contracts. Therefore, this is a general relationship. Okay, they've got a lot of responsibility to manage all the different transactions, client relationships, and such. So it's more than one property. Excuse me. Okay, so do y'all get that? 414B, it is general, it's broad. Okay, it is not universal. Universal meaning they would probably also have multiple enterprises, anything that that person owns or has, and they may have a power of attorney to do a lot more. So that's universal. You look at the universe, that is extremely broad. Okay, general, you know, it's more general on that particular enterprise, everything that deals with the operation of that particular enterprise. Let's see, Kamanani says, one realtor, one property, special. Yes, general is more than one, okay? General is no more than one. No, general is broader. General is one. So think of general in the military, a general topic. It's broad. Okay. Got the difference. Okay, good. 414. Already did. Okay, 15. This will be the last national question for the day or for the morning. So 15, a property seller empowers an agent to market and sell a property on their behalf. The kind of agency represented is to sell a property. Okay. A, general, B, special, C, universal, or D, no agency. Okay, Kamanani, got you. Okay, after what we reviewed, you should get this one. Oh my gosh, I almost typed the wrong answer. Yes, you all are on a roll. The answer is B, special, right? As Kamanani said here, one realtor, one property, special, right? It's one specific property, therefore we're a special agent. One specific property, one client, special agent. All right, any questions on national before we transition into Texas state questions? So give me a moment while I transition. So type your question in the chatty chat. Okay, let's see. Avion, Washington. It states one of her properties. Okay, shoot, I just transitioned. Yes, it's one of her properties. That means it's one property, okay? A special agent deals with one specific property. The fact that it's, no, it doesn't say, you might be talking about, no, the question actually, okay, number 15, a property seller empowers an agent to market and sell a property, not one of her properties, Avian. It's a property, okay? So it is a special agent. Okay, so let me transition again to Texas State. Melanie, thank you for the tutorial this morning. Have a great day. Yes, thank you. I'll be working the rest of the day. So have an awesome day. Okay. So we now go into Texas State questions. So anybody that's here national, you are welcome to stay and just pay attention to how, really to read questions and pick out keywords that'll help you answer, help you with the answers. And the answers, a lot of times, well, the majority of the time, they have little keywords also. Okay, so we are now on number 13.6 on the Texas State. Continuing from last session. Okay, and so last session, had to do with, so standard of conduct in brokerage practices. Okay, that's what we're dealing with right now. Standard of conduct with brokerage practices. And that's one of the areas that is missed a lot by students taking the exam for Texas and probably also for other states. All right, number 6, 13.6. A sales agent is interested in selling a duplex he owns that is not making enough money. In fact, the units are in the red with no end in sight. It's a what do you call it? A cash dumper, okay? It eats up all your cash. A cash hog. Which of the following is true? So they're interested in selling a duplex they own that is costing them a lot of money. A, the licensee is barred from personally selling the property since he is licensed. B, the sales agent may sell the property provided that he disclosed the loss in a pro forma profit projection. C, the licensee may sell the property without restrictions regardless of the profitability. Or D, the sales agent may sell the property provided he make property disclosures as to his license status. Sometimes there may seem like several correct answers, but there's only one best correct answer that they're looking for. Okay. The examiners that produce these exams. Type your answer in the chat. Texas State questions. Oh, and by the way, all of you who are watching on YouTube, hey, remember to send me some love and tap that thumbs up, okay? Not a thumbs down, okay? No negative comments. We stay positive here. That's how we're going to pass. We have to have a positive mindset, okay? A good mindset is very important and critical. It was for question 414, okay? That was general. It was her property enterprise. Okay, Evian. It was the enterprise. And an enterprise includes, maybe property management or whatever it is. Includes multiple properties. So number 6 is D. The sales agent, may sell the property provided they make proper disclosure as to their license status. Anytime we sell a property of our own, we must disclose, right? Because we are educated, we have tested, we have taken courses. So we are more knowledgeable than the public individual, than the buyer and the seller. Some of them are extremely knowledgeable, okay, because they're investors, but on the average. So anytime we have a real estate license, we must disclose. Number 7, 3 of the following statements constitute a violation acceptable brokerage practice. And one statement represents acceptable practice. Which one is not a violation? Okay, so one of the following is acceptable. A, sales agent tells a buyer that the seller can paint the house in 2 days, a job that takes 4 days. B, a sales agent places a new sign on a property advertising the reduced price despite the fact that the listing expires in less than a week. C, a broker uses $500 from his trust fund to pay a personal fee and redeposit the money back into the account within 24 hours. D, a sales agent tells a buyer that he guarantees the property will appreciate as it has for the last 10 years. Do we have a crystal ball? Can we guarantee anything? That's our opinion. So let's see. So far I have BB. And yes, the answer is 13.7B. A sales agent places a new sign on a property advertising a reduced price. We can do that, even if it's going to expire in a week. Our goal is to get a ready, willing, and able buyer, even if it's on the last day. We can always, once we get an offer, we can always get an extension to the listing. Awesome. You might hear a little dog barking in the background. Don't let that distract you. All right, number 8. Which of the following statements would subject a licensee's license to suspension or revocation? Okay, so something the licensee did wrong, okay, that can cause their suspension or revocation. A, including the broker's business identification on an advertisement. B, receiving a 10% commission on a property sale when the going rate is 6. C, placing an excess number of signs on a property for sale. Or D, persuading a represented seller to hold off on selling until the listing period ends, at which time the sales agent can get her a much better price. Okay, type your answer in the chatty chat. Yes, the answer is D. Persuading a represented seller to hold off on selling until the listing period ends, at which time the sales agent can get a much better price. No, our goal, our fiduciary duty is to get them an offer, a ready, willing, and able buyer now, right? Not to hold off until we think. Okay, that's not our job. To think and decide what we want. It's the sellers and it's our client's decision. We guide them and advise them with facts and experience. All right, but we use facts, numbers, okay, trends in order to help our clients make a decision. Number 9, 3 of the following are license law violations and one is not. Which one is not a violation? So one of the following is true, right? License law violations are 3 of the following. One is not. A license forgets to mail a copy of a signed transaction document to a principal. B, a broker distributes trust funds during a closing. C, a broker makes one monthly payment into the trust fund on the first business day of every month. D, informs a prospective buyer that a property might still be for sale even though the sale has closed. Type your answer in the chat. So what can a realtor broker do? Okay, that is not a violation. No, it is not A. Think again. Okay. Keep in mind, we've done these questions before. I like to repeat them, because what do I say during the class? I say, repeat the questions that you study until you get them perfect, get 100. Most recommend that as long as you get an 80 score when you're taking tests at home, that you should be good. I say, go and get as high as a score as you can. The more you repeat, repetition will help you understand and learn, okay, the questions and the answers. So the answer here is B. Okay. A broker distributes trust funds during a closing. That is the time when trust funds are distributed. So if a broker has, okay, a trust fund, okay, and keeps the money instead of sending it to the title company, then that's when it's distributed. Typically now, any trust funds or earnest money or anything that is applied with a contract as a consideration, it goes to the title company or the escrow officer, because the escrow officer can be an attorney, and it's held there, and then it's distributed during closing or after closing. After everybody signs, okay, and the transaction has been executed, that means the transaction has closed, and all the funds are paid. Everything is paid during the closing. Okay, the escrow officer will send payments from the money received from the buyer or the borrower, okay, because the money is coming from the lender. So let's see, some of you said, see, a broker makes one monthly deposit into the trust fund on the first business day of every month. So what monthly deposit are they making? Okay. The correct answer to that is not. So we don't make deposits into trust funds. Okay. As soon as we get any funds from clients, broker has to deposit within 2 days. If it's once a month, then what are they doing with the money in the meantime? Then you can't hold on to it. Okay. So the best answer here, and that is not a violation of law, is the broker distributes trust funds during a closing. Do y'all get that? Because some of you answered, let's see, A license forgets to mail a copy of a signed transaction. That is a violation, okay? That we are required to provide our clients a legible signed copy of any document. So once documents are signed, and they can get it via email, and nowadays, right? Or we have our softwares where it keeps all the documents, where they sign online and they have access to a document there that can be downloaded. Some clients will request a document to be mailed. Okay, it's going to take a little bit longer, but after they get it online or in an email, we also mail it to them. It's kind of rare now, but it is doable. Okay, y'all get that? You got C. So remember, trust funds have to be deposited by a broker within 2 business days. Okay, not on the first business day of every month. And a copy has to be given to a principal once signed. And then the last one, nobody chose the last one. Okay, very good. All right, you got it. Very good. Number 10. Did I show it? Yes. Which of the following constitutes the unauthorized practice of law? Which of the following constitutes unauthorized practice of law? A, advising a seller that her property has a title defect. B, completes a promulgated contract. C, informing a buyer that a property purchase entails numerous legal ramifications. Or D, advising a seller to obtain sufficient property insurance. Write your answer in the chat. Only one replier, only one participator for this question. Okay, well, some of you may be driving, so I don't want you to be typing. Yeah, the answer is A. Okay, advising a seller that our property has title defects. We do not do that. Okay, attorneys do that and the title company. Not C. It is A. Okay, very good, Evian and Cindy. Okay, we're going to be doing less state questions because we run out of state questions really quick, because what on the exam you actually have in the state of Texas, you have 40 questions, okay, for a realtor. And on the national, you have 85 for a realtor. A broker has also 85, but they have to have a higher score or answer all 85 and graded on all 85. On a state, a broker has, I believe it is 60 questions versus a realtor has 40 questions. Okay, so the answer was 1310A. Okay, so we're going to be doing shorter questions for state, as that's the way that you actually deal with it on the exam. So we just did 5 questions. We're going to call it a day with that. And I'm going to let you now take a rest, take a break, and then continue studying if that's what you're going to do. Remember to study in short periods, okay? 20 minutes, 30 minutes. What I've learned from Jim Quick on YouTube, okay, is he teaches on how, he educates on how to help yourself learn. Says you learn the beginning, you remember the beginning of every 20-minute session, the beginning and the end of every 20-minute session. Every time, everything in between, more than likely you will forget. So study more often in short sessions. So if you only have 30 minutes to study, awesome. You'll remember the beginning and the end. However, study every day. Make it a habit to study some vocabulary, even if it's just 5 words, 3 words, okay? And learn those, okay? Do flashcards or, your list, but don't overwhelm with studying so many in one day or in one session. Because sometimes when you pull away from something that you're doing and you can't resolve, the mind relaxes and you come back and boom, a light bulb goes on and you get it. So study in short sessions every single day. Repeat the vocabulary and repeat the same questions that you're studying from your prep book, from YouTube, tutors, instructors, schools, wherever you are studying your material. And of course, from here, okay? And keep repeating the same questions, okay? It doesn't hurt you. It helps you, okay? If you have one book, and you can't afford to be buying a lot of books, you need to save your money for the actual starting of your real estate business. Use the same book and study the same questions over and over till you get 100, to where you can read the question and the answer and boom, okay? Be able to answer it right away. And pay attention to the little keywords that I point out. And, in the questions and in the answers, read them carefully, because we all make mistakes sometimes when we're reading too quickly. So let's see some comments here. All students learning, keep reaching. See you all next time on the tube. All right, Kamanani, thank you. Have an awesome day. Cindy, and maybe spend more time on it. Test is on the 13th. Ooh, wow, that's 3 days from now. Yes, spend more hours, but take regular breaks, okay? Please do it, all right? I'm telling you, because I have to do it myself, and I'm learning from experts that educate about how to learn. So you've got to have the right mindset. If you don't have the right mindset, if you're self-doubting yourself, if you're negative and, low self-esteem, low self-worth, you doubt yourself, it's going to be very difficult, okay, to pass. We've got to focus on changing our attitude and thinking positive. Say, hey, I can do this. I'm doing it. I did it. I passed, I passed, I passed. Okay? Change the attitude. If the same thing you're doing over and over and over is not working, then make a change. Okay? Yes, thank you for everything, Lillie. You're an amazing mentor. Oh, thank you so much. I appreciate it. Kathleen, thank you. Thank you all. And Kamanani, congratulations at Cindy. You will hit it out the park. All right. Yeah. Woo! Got it. All right, y'all. It's been awesome. Have an awesome day. If you haven't been to my YouTube channel, hey, go to the YouTube channel, tap that subscribe button, click that little bell so you're the first to get notified, and give me a thumbs up, no thumbs down, okay? If you found this useful. Okay, remember, I am also a practicing realtor with eXp Realty. You'll be interviewing. Hey, set up a chat with me on my Calendly. And there are links to books at the bottom that you can purchase on Amazon. So you click on my link, and anything you purchase of books or anything else actually that you might purchase, Amazon will pay me an affiliation fee. Okay, so comments. I was asking if Monday we can start with state and spend a little extra time on it. Yes, we could do that, Cindy. Well, your test must be in the afternoon. So if that's the case, okay. Thank you, Kamanani. All right, awesome, y'all. Until next time, catch you later. I passed, I passed, I passed. Watch some of my other videos on vocabulary and national questions and state questions. Until next time, catch y'all later. Love ya.